Fran, come out and see the new car. It's great. Let's go for a ride.
I can't believe it's really ours. It's beautiful. It's just what we wanted. Let's go show Judy and Bill. I told them we'd come over as soon as you got home.
Funny, it's a brand new car. We shouldn't be having trouble already. Not for what this baby cost us.
What do we do now? The dealer has our money, and we have a car that won't run. They better do something and do it now.
Well, we're not going anywhere in this car. Let's go in the house and figure out what to do next.
On this tape, Judge Wapner is going to talk about automobiles and driving. We all know the starring role cars play in the way our country looks and works. If you have to cope without a car, you know how important a car is to the way we live our lives. But many of us probably haven't ever really stopped to think about the vital role law plays in the ownership and operation of motor vehicles. Yet it's in connection with automobiles that most of us have our most frequent contact with the criminal justice system. Motor vehicle accidents account for a large percentage of all litigation. Auto repairs cause a large number of small claims court cases. And vehicle purchases are among the most expensive contracts most of us ever enter into. Motor vehicles and the law is a broad topic, and Judge Wapner will discuss it in the order most of us typically encounter it: licensing, accidents, tickets, buying a used car, auto repairs, and buying a new car. First, let's examine the privilege and process of the driver's license.
As important as it is in our mobile society, driving has always been considered a privilege rather than a right. Americans have a right to travel, but not a right to drive. Among other things, this means you don't have a right to a jury trial before your license is revoked. You have few remedies other than trying again if you flunk a driving test.
How many traffic violations am I allowed before my license is suspended?
Individual states have discretion in setting their own standards for granting licenses and in their procedures for suspending or revoking them. Many states will suspend a driver's license after a driver has accumulated a set number of violations in a stated period of time. Usually it's 3 violations within a 1 or 2 year period. This is sometimes known as the point system. For instance, driving through a red light might be a 2-point offense, while reckless driving might be 4 points. When a driver exceeds the maximum number of points within the time period specified under the state law, his license will be suspended. There is one legal right you can be sure of. Every state requires that you be given a hearing before your driving privilege is revoked. During that hearing, you must be permitted to confront and cross-examine witnesses. There are at least 3 consequences of each state having the power to set standards for drivers in its territory. 1, teenagers licensed in their home state might not be able to drive in another state if they're below the minimum age for a license in that state. 2, a person may not legally drive in a state that has suspended or revoked his driver's license, even if he has a valid license from another state. And 3, a state may require that new residents apply for a license within a short period after moving to the state, even if the move is only temporary. These laws are of particular interest if the driver is a college student. Some states require college students to apply for a local license if they want to drive a car while at the college in that state. I recommend that you check with the Department of Motor Vehicles in the out-of-state locale where you or your child is going to be living during college years so that you can comply with the law.
Once a person is a licensed driver, the opportunity arises to be involved in an accident. Statistics show that a majority of new drivers are involved in an accident within their first year of driving. Fortunately, most of these are minor. Experience and maturity help reduce the likelihood of an accident, but it's the rare driver who's never involved in any accident, and we all need to know how to respond. Here are 10 rules to go by if you're ever in an auto accident. Rule number 1, stop, no matter how minor the accident.
The penalties for hit and run are very severe. After such an accident, stop at the nearest point you can without obstructing traffic any more than necessary. If you hit a parked car, try to find the owner. If you can't, leave your name, address, and an explanation on the windshield of the car, and go to the local precinct house to notify the police.
The second rule, if you're in an automobile accident, is render aid to anyone who was injured in the accident.
Give first aid to the extent that you are qualified, but please don't try to move an injured person in any way that could add to the injuries.
The third rule is get help.
Call for an ambulance or fire engine if needed, or flag down a motorist and ask him to call or radio for help. Always call the police unless the accident is nothing more than a fender bender. Whenever there's an injury or significant damage to property, the police must be notified.
Rule number 4 is protect against further damage.
This means use your car's flashers, flares, warning triangles, or other vehicles' headlights to warn approaching motorists of the accident. Stay out of the lanes of traffic. Too often we read of tragedies in which someone is killed standing by his car after a fairly minor accident. You don't want to become a statistic.
The fifth rule to go by if you're in an automobile accident is gather and record information.
Most states require you to exchange personal identification as well as vehicle and insurance information with others involved in the accident. Write everything down. Get the names, addresses, and license plates of witnesses. As soon as possible, diagram the accident and make notes on weather, lights, visibility, and road conditions. Take pictures of the scene and the automobiles involved. If you don't do it right away, then certainly handle this the very next day. Get the name and badge number of the police officer at the scene and find out how to get a copy of the accident report.
Rule number 6 is be careful about what you say. Try not to express an opinion about who was at fault.
Even if you think you may be to blame, it might actually turn out the other driver was even more at fault than you were. When talking to the police, concentrate on the facts, not opinions. Keeping your cool at this point can save you all kinds of trouble later on. Even if you're totally blameless, it doesn't do any good to antagonize the other driver.
After an accident, rule number 7 is see a doctor.
Injuries aren't always immediately apparent after an accident. Don't accept a settlement until you get legal advice and see a doctor. A settlement with the insurance company depends in part on the injuries that you have sustained in the accident.
The 8th rule is notify your insurance company as soon as you can.
Failure to promptly notify your insurer could affect your coverage. If you're driving someone else's car, that person's insurance company probably has primary responsibility and should also be notified. Your insurance company should be able to obtain a copy of the police report to process your claim. If you're solely or partially responsible for the accident, your insurance company should provide you with an attorney for your defense in a civil lawsuit. If the other driver is at fault, his insurance company may pay you for the damages to your car before settling your medical or personal injury claims. And remember to have a mechanic check your car to see that it hasn't sustained some hidden damage from the accident.
Rule number 9 is report the accident to the proper authorities.
Most states require you to report an accident to the Department of Motor Vehicles, although some states exclude accidents in which no one was injured and property damage was very minor. Others require a report only if no police officer came to the scene. Find out who the proper authority is in your locale to report the accident. The police or sheriff's department may be the place to inquire. If there was damage that needs to be reported to your insurance company, you will need to file a police report so you can submit a copy with your claim. I think it's always wiser to be conscientious and report any incident, no matter how minor, especially when the accident wasn't your fault. The report will probably help you prove your case.
Finally, accident rule number 10 is contact a lawyer if you think you may need to file a lawsuit against the other driver.
As I said before, if the other driver is suing you, your insurance company will normally provide a lawyer for you. In any situation, always get a lawyer's advice before giving any statements to anyone. Protect yourself. Almost everyone is aware that our attitude toward drunk driving has changed substantially in the last few years. The days of the wink, and wrist slap are long gone. I've seen statistics that seem to show that drunk driving has declined. But on our streets and in our courts, it remains a frequent and very serious problem. Drunk drivers still account for about half of all fatal auto accidents. Unfortunately, most drunk drivers aren't caught before they kill themselves or someone else. Because many people may occasionally be tempted to drive after drinking, I hope it's sobering to review the broad changes in laws and legal procedures that reflect our new attitudes. For instance, in most states, you can be arrested for sitting drunk at the steering wheel of a parked car, even if you haven't driven it away from the curb. If you have the keys and are in the driver's seat, the law presumes that you have control of the vehicle. In fact, a majority of states say it's illegal to have an open alcohol container in a vehicle. Even empty beer cans or liquor bottles that are within easy reach of the driver are enough for the police to assume the driver consumed the contents. Every state in America now defines someone as legally drunk if his blood alcohol level is 0.10% or higher. In fact, more and more states are creating a second, lower threshold at about 0.05%, which is usually called driving while impaired. While driving while impaired usually carries a lesser punishment than driving while intoxicated, it's still a serious charge to face, and these are generous limits. How much you can safely drink depends on a variety of factors, including body weight, stress levels, other medications, length of time since you've eaten, etc. The safest way to drink and drive is to stick to non-alcoholic beverages. Another example of the tightening of our drunk driving laws is that the courts have been allowing police more leeway in detecting drunk drivers. Sobriety checkpoints have become a popular tool for identifying drivers who had a few too many, and most major cities have established areas where the police randomly stop vehicles to check for evidence of drinking. In most states, the courts have ruled that a driver doesn't have a right to consult an attorney before taking a breath test. While you're completely within your rights to refuse to take the test, it seldom makes sense to do so. As a condition of obtaining your driver's license, you give the state your implied consent to alcohol testing when you're suspected of driving under the influence. In most states, if you refuse to take the test, you'll automatically have your license suspended, and you can still be prosecuted for drunk driving. Legislators have done a lot more than toughen standards and punishments. They've also narrowed the grounds for contesting a drunk driving charge. In many states, there's very little a defense attorney can do if a blood test shows 0.10% or higher.
I passed a roadside breath test for alcohol. Can I still be convicted of drunk driving?
Yes, you can be convicted if whatever amount of alcohol you've consumed has affected your ability to drive. This is determined by tests which are designed to assess your awareness and coordination. In addition to the breath test, these may include a balance test, walking a straight line, touching the tip of your nose with the first finger of your left hand, or reciting the alphabet. If it's your first offense, you may or may not go to jail. If you're a repeat offender, however, you'll almost always get substantial jail time. In addition, when drunk driving results in serious injury or death, some states have made it a felony. Lengthy license suspensions, stiff fines, community service, and mandatory attendance at alcohol abuse programs are also common. A typical sentence may combine at least 3 of these punishments. We are increasingly being charged with a legal duty to help prevent drunk driving. Bar and liquor store owners have long been under a duty not to serve or sell obviously intoxicated customers. In many cases, they've been held liable for harm caused by a drunk person they supplied with alcohol. Now courts in some states have begun putting a similar responsibility on those serving liquor in their homes. In those states, a host who serves an obviously drunk guest, knowing he's likely to drive, can be held liable right along with the drunk driver for any accidents that he may cause. If this seems all a bit scary, that's the idea. It's not as frightening as the thought of those drunk drivers sharing the road with you and your loved ones.
Almost everyone who drives has gotten a ticket or two, at least for illegal parking. And it seems that everyone also has some story or another about the unfairness of a traffic ticket or the injustice of traffic court. These stories are so common, it would seem the traffic court system can't be all that unfair if everyone's been treated alike. But there are reasons why so many of us feel put upon, and there are also ways to minimize the damage tickets can cause to your driving record and insurance rates.
There are two basic reasons why the traffic enforcement system often appears to be unfair: selective enforcement and the profit motive. Let's talk about each of these separately.
The traffic enforcement system seems unfair because of, what do you call it, selective enforcement?
Let's be honest. Almost all traffic violations go unpunished. On many roads, a majority of drivers technically are speeding. A high percentage of right turns at stop signs and red lights are made without complete stops. Running yellow or red lights, failing to signal lane changes or turns, and following other vehicles too closely are all pretty common. Violations are frequent, and yet punishment is so sporadic that "why pick on me?" or "why this time?" is a pretty natural reaction. We're not angry because we were innocent. We're mad because this time we got caught. It has also been demonstrated that some kinds of cars and some kinds of drivers are more likely to get stopped than others. While most of us think that a tougher standard for new drivers is a good idea, it's easy to see why young people driving sports cars might disagree.
The second reason why the traffic enforcement system seems unfair is the profit motive.
It's true that in some areas, traffic and parking fines are a recognized source of municipal finance. Most systems make it tempting to pay the fine and avoid a hearing, even if the ticket was unfair. It can be costly in time and aggravation, if not money, to have your day in court.
If I haven't paid the 10 traffic tickets I've gotten over the years, can I be arrested and be forced to spend the night in jail?
Yes, you can. Too often people ignore traffic tickets. They forget that this piece of paper is both the notice of a fine and a summons to appear in court. If you don't pay the fine or appear before the judge on the specified day and the time, a warrant may be issued for your arrest. Another action that may be taken if you have many outstanding tickets is that the police may place a boot on one of your car tires. Sometimes it's called the Denver boot, because that was the city where it originated. Whatever term it goes by in your city, it's a heavy metal device that locks around a tire so that you can't drive the car away. The boot has been challenged often, but courts have consistently ruled that it is not a violation of your constitutional rights. The fact is, at some time or another, you may find yourself on the wrong side of the traffic laws. So let me give you some practical advice on how you should deal with the police and the court on traffic matters.
What tips do you have if a driver is pulled over by the police?
My first tip is to ask identification from anyone not in uniform. Policemen sometimes work in unmarked cars or while not in uniform. A police officer will normally show you a badge when you're first stopped. Write down the name and badge number so that you can get in touch later about any questions you have regarding the incident. A valid police officer will always be happy to show you identification. Second, be polite and try not to argue with the police officers. Keep in mind that police officers are human beings just like all of us and will be more likely to let you off with a warning rather than a ticket if they find you to be friendly rather than combative. Third, don't resist arrest. It's a crime. If you resist arrest, the officer is entitled to use reasonable force to take or keep you in custody. If the arrest was improper or if excessive force was used, you may take legal action later. The fourth thing to remember when dealing with the police is that search rules are complicated. The search rights of police in connection with a traffic stop are often quite limited, And sometimes a police officer may not have the legal right to search your car. The wise thing to do, however, is not to object if the police officer performs a search. And if you believe the search was illegal, then you can challenge it later in court. My fifth tip is sign for your ticket. You'll probably have to sign for it in order to avoid arrest. Your signature is not an admission of guilt. It's either a promise to respond to the ticket by paying a fine or appearing in court, or it's a simple acknowledgement that you have received it. It's important to realize what's at stake in a traffic ticket. As I've said, drunk driving is a very serious offense. The loss of your license is also serious. Tickets issued in conjunction with an accident may affect the outcome of personal injury cases. And if you have a series of violations, it may increase your insurance rates. The more serious the stakes, the more reason there is to defend yourself against the charge.
When should I challenge my traffic ticket in court? Can you give me any tips if I decide to do so?
If the matter is serious, don't avoid a court appearance simply because of fear or inconvenience. By the same token, think twice before making a court appearance in a minor matter unless you have a good defense. Don't hesitate to call an attorney to see whether a court appearance is warranted, to learn what the procedures are, or to get advice about preparing a defense. Talk to the prosecuting attorney before your case is called. You may be able to obtain a reduced charge if you're willing to plead guilty. If you decide you want to challenge your ticket in traffic court without an attorney, there are several things you should do in order to give yourself the best chance of success. First, make sure you understand exactly what you are being charged with. If it's a speeding ticket, the answer is pretty obvious. If, on the other hand, your ticket is for following someone too closely or tailgating, it may help to get a copy of the pertinent law and find out exactly how closely you are allowed to follow someone in certain traffic conditions. This may point out weaknesses in the police officer's case against you. Second, inspect the scene of the crime. This may help you find the reason for your mistake. Perhaps a tree was hiding the stop sign that you passed, or the red traffic light that you mistakenly went through wasn't functioning properly. Third, gather all witnesses, make any diagrams, or take any photographs that you think may help your case. If, for instance, you passed a stop sign because a tree was blocking it from view, get a photo of the tree, showing how it hid the sign. If any witnesses were in your car who can testify that you weren't speeding, bring them along to your traffic court hearing. This is all evidence in your favor which the judge will take into consideration when deciding your case. Fourth, go to the traffic court a day or two before your case is going to be heard to see how the court works and the procedures they use. This will help you to be less intimidated by the whole process. Fifth, rehearse what you are going to say to the judge until you feel very comfortable with your presentation. You may even want to practice in front of a mirror a few times. Sixth, be reasonable in your presentation. For instance, don't attack the police officer as a blundering fool. Instead, provide a valid and believable explanation of how the policeman could have made the mistake that you think that he made. By the way, if the police officer who gave you the ticket fails to show up during your hearing in traffic court, you may have a pretty good chance to win your case since the officer can't give another version of the incident. The traffic court judge who sees that you've done everything that you can to research your case and plan your presentation, taking time off to come to court, will be more likely to believe your side of the incident and find you innocent. By the same token, an unprepared and shoddy presentation may give the judge the impression that you just have nothing better to do than waste the court's time with a meritless defense. Being prepared for court is very important. I know this firsthand for having served in traffic court during my early years as a judge. I remember one instance when a man came before me on a charge of speeding. The police claimed he was driving 55 miles an hour in a 35-mile-an-hour zone. The gentleman, in defense of his position, claimed that he couldn't have possibly been speeding because his Cadillac didn't go more than 35 miles an hour, even when the gas pedal was pressed to the floor. I took him up on his claim and told him that if he waited until the end of the court calendar, My bailiff and I would join him in his car to see how fast it would go. Well, we got together and drove down Olympic Boulevard in Los Angeles. He put the pedal to the floor, and sure enough, the car didn't go faster than 35. He proved his claim, and I pronounced him not guilty.